solicitor. I'm also registered in Zimbabwe to practice as a legal practitioner, so I've been dually admitted in both countries. Now, I'm sure this is an interesting topic, and the good thing about it is that I've got my senior colleague, Rumi Buzawabaya, who obviously at some point will also chip in, because this is what we do as part of our bread and butter in our practices. I will not be prompting you, say, for the slides. You have to catch up with me, so you have to concentrate. Okay, so there are three main stages which I call milestones in this process of getting a sponsor license. And by the way, sponsor licenses are not only made for the healthcare services or the social care services. Sponsor licenses are there across the board, where there is a shortage of skilled workers, or where there's a shortage of employees. You advertise, you can get in local employees, then you can apply for a sponsor license. In our practice, we've got clients ranging from insurance companies, healthcare companies, and even another one in the tourism sector. And it's across the board that we've got clients that have got sponsor licenses. But these are the major, what I can say, the milestones of a sponsor license. The first thing is for you to apply for a sponsor license. And to apply for a sponsor license, it used to be an easy process. When we started, you would submit 1, 2, 3, or 4 documents with the Home Office, and the sponsor license will come out. You would apply for a sponsor license, maybe without even getting a visit from the Home Office. You will get a sponsor license. These days, the Home Office might want to visit you during the process of applying for the sponsor license, and also the process is now getting more and more stricter. A lot of more evidence is required. The Home Office wants to really establish that you are a genuine, established trading company. It doesn't matter whether you're a new startup or you've been trading for a time. In fact, if you're a new startup of a business, then the paperwork that is required might be less than a company that has been operating for a number of years, because you have to produce a number of documents. So the process starts with applying for the sponsor license. It's a process that is done online. There's evidence that is required to show that you are, for example, registered with the company's house. You've got your HMRCE registrations, which come automatically anyway once you register a company. Then the HMRC will pick your information, your corporate tax, your VAT, if you're eligible for VAT, the payee, and so forth. You've got a bank account, and you've got all the necessary documents that are required, the job descriptions, the organizational charts that you have, the personal specification, evidence of maybe the adverts that you've submitted on various platforms, whether on your website or on advertising platforms such as Indeed or whatever you do on social media and so forth. So once you do your application, which also help clients to do the applications, once you do your application, I will not go through how you do the process itself because we don't have time, we were running short of time. If you do your application, on average, the applications take around 8 weeks for the decision to come out. But there is also a process to expedite the application if you pay any additional £800 for the application fee. The application fee for a small company is around £536, and if you're a large company, about £1,450 for the application fee. But if you pay the additional £800, then someone within the company will have to wake up every day in the morning early to submit an email to the Home Office, so that your email might be picked by the Home Office, and then they might expedite your application and it goes on priority. If you want someone from me, from my office, from Rumbi's office to wake up in the morning to do that for you, we will gladly do that for a fee. You pay us, we make someone wake up and submit the email. So that's the first milestone to make the application. So if you are struggling for employees, and a lot of people in the healthcare sector do struggle for employees, you can apply for a sponsor license. And there is a lot of requirements that will be there on the part of the employer, and on the part of the employee. I'll talk about the employee later. So let's assume that you've made your application for a sponsor license. My second milestone will be that assuming that your application has been granted, because the Home Office might grant your application, they might refuse your application, and if you have been refused, then you have got at least 6 months cooling off period before you can make another application. That is why it is very important for you to make sure that when you make your application, everything is up to scratch so that you will not get a refusal. Sometimes if you have not followed the correct processes, they might do what we call a rejection. If they send you a rejection, it's not a decision based on the merits of the application, it's a technical decision that they've made. So you can make another application straight away, submit all the documents that you are supposed to submit, and follow all the processes that you need to follow. So I'm assuming that you have been granted your sponsor license. If you have been granted your sponsor license, the next thing is you get your login details for you to log into the sponsor management system, the SMS. You get the username, the code, and everything like that, and then you log into the system. And onto the system, there's mainly three personnel that are very active. There you've got an authorization officer, then you've got a level 1 user who has got almost all the powers for the company as a level 1 user. Then you've got a level 2 user who has got less powers than the level 1 user. And the SMS is where you do all the processes of managing the sponsor license, generating the COS for employees, updating the Home Office, any payments that might need to be made, and so forth and so on. And this has to be done, especially the updates, they're looking after the SMS, and if you've got an update that you need to do to the Home Office, if you've got an update that has to be done, it has to be done within 2 weeks of that update. If an employee has left, for example, you've promoted an employee from one position to the other, and anything that has changed, you have changed your operations in the company. For example, maybe you made an application as a domiciliary care company, and now you are a supported living company. Those are some of the updates. People take them for granted. Some of these updates, changes that happen in the organization, but when the Home Office then comes to do their reviews, they might start to picking on such things that you do not update us on such information, on such things. Therefore, you have to explain to us, we're putting you on suspension and so forth. Those things have happened out loud. I'll let you other reasons that I've learned from practice why sponsor licenses have been suspended and indeed have been revoked. Just for you to know, having a sponsor license is not a right. Even if you have it now, it's not your right. It's a discretion of the Home Office. They can come and take it away from you today, and you and your 30 employees from Zimbabwe are stuck. And the employees will get a letter to say 60 days, get another letter, another job, and then they'll just go to company B next door, get another COS, and then they can get ongoing, but yourself, maybe after 12 months, you can then reapply for a sponsor license from the Home Office. So milestone number 3 is that now you're now in your SMS, and when clients come to me, because I'm confident of my work and I'm confident of the work of my employees, I tell them that you can now start the recruitment process. Because the recruitment process is, some of you here, I know a lot of you here, you've had experience with the sponsor license. The process itself, from your side as an employer and from the side of employment recruitment, is long and tedious. So sometimes you need to then have your employees do all the necessary steps, like train them. Maybe you've got your own online training that you give them, or you've asked them to go to Red Cross or Wilkinson's or Giri, wherever you've asked them to do. You also have, the employees have to do the English test, which they have to fall on every aspect of their English test. They have to score at least 4.0, not just the overall mark, as most employers here make a mistake and just believe It's just the overall mark, and then the Home Office will refuse the application. So the employer, you have to do the employee rather, you have to do their English test. They have to do things like the TB test, police clearance, and so forth, and other requirements which will be there. So point number one, you make an application for the sponsor license. Once you get a sponsor license, you get into the process of managing the sponsor license itself. Then you recruit your employees, they make their visa applications, and at any stage you can include a legal representative, or you might not include a legal representative. It's up to you as a business what you want to do there. Okay. So that's milestone number one, which I was explaining. It's a skilled worker visa. Okay, so sponsorship license is essentially that permission. Okay, move on, Mr. Yeah, so okay, let's stick to that. So that's milestone number two, where you manage your SMS. You have to comply with the duties and responsibilities mentioned in the sponsor management system. You generate your COS, you make payment of the fees. So those are the different levels of the users as well. The authorizing officer has got the overall responsibility for the actions of the business and employees. Level one are responsible for the day-to-day use of an online sponsor management system. Level one, you're allowed to get someone who's outside of your organization or of your business. So for example, you know that you don't have the expertise to run the sponsor license management system yourself, or you are too busy for that, then you can engage someone. You can engage Tanlo, you can engage Tulia to manage the sponsor license for you, and then they will be able to generate all these things. And one thing that normally happens is on generation of COS, what the MC was saying, do you want to bring your relatives? That is always a tricky question, but if you are to bring your relative, it's allowed, isn't it? But you are not the one who's going to generate the sponsor license. So if you run your own business and you want to bring your relative, you've got a justification for bringing your relative, and you are the only person there, then you might need to appoint a third party or someone else to then generate that COS on your behalf for you to be able to bring someone. But you can do the COS level one, someone can do in, and these roles can be done by a single person or can be done by different people. It doesn't really matter. So can you put forward milestone number three, which is the visa application itself? So when you are making a visa application, regarding the job, one must work for a UK employer that has been approved from the Home Office, which is they've got the sponsor license, they've been assigned the COS, must have a job that is on the eligible occupations. So the job must be on they must have a SOC code that is on the available occupations. And some of the advice that we'll give our clients is they really know what they want a person to do, but the job is not necessarily on a SOC code. But we then advise them on how to align the job to a SOC code that is accepted by the Home Office. Like I said, I was speaking about laboratory technicians, for example, because we have got clients who we have got laboratories, we've got clients who have got insurances and so forth. But some of the it might be the level of the salary, it might be the level of expertise that the client wants, but it does not fit into the SOC code. But we help you in doing all those things. The English test that has to be passed, it's either they write the English test or they do an ECCTIS exemption, they apply and then they get that one, and then you have to meet the rest of the criteria. It's also important that the salary must be at the acceptable rates. It has to be over the minimum wage. I will talk about the employment law. So it's either at the going rate or above, off my head, it should be above 20,600 or at the acceptable rate of the salary. Okay. So those are the milestones. The recruitment process, since we are limiting ourselves to the social care visas or the care visas, the Home Office does not necessarily state the minimum qualification of a carer, does it? No, it doesn't mention a minimum requirement of experience or qualification. But what I always say to my clients is that, look, you are a prudent employer. You are a genuine employer. You are a serious businessman or woman. You cannot just all of a sudden go and get your muzukuru who's looking after cattle in a Morewa and say, I'm going to give you a COS, and then try to justify it to the Home Office. That will be a difficult position for you when the Home Office pays you a visit. Try by all means to recruit someone whom either they've had some kind of experience or some kind of education on the care visa or care sector, working in there, or give them some kind of training. There's a lot of training. Some people go for free online training. Some people have got their own bespoke in-house training that they're giving their own employees before they bring them to the UK. Some say we prefer someone who has got a Red Cross or Wiggins and so forth and things like that. There is nothing bad with those qualifications. I've made some comments on social media. There's nothing bad about those qualifications. But as a prudent employer, make sure that when they come here or when they are still in Zimbabwe, or whatever part of the world that you are recruiting them from, you have given them some kind of training, some kind of qualification that makes them fit for the job. If you are a specialist, for example, you deal with clients who have got spinal cord injuries, then make sure that they've got at least an understanding of dealing with someone who's got a spinal cord injury. If you deal with someone like my friend Mr. Gonzawa, he deals with young people who have got challenging behavior. So he makes sure that he trains them to be able to deal with those people. You teach them about restraining, whatever things that is necessary for that. And then they have to meet all the rest of it that is required. The Home Office wants to know that you've got all the proper systems. Sometimes to know about a business, and I'm saying I'm on an Amkanya. And I'm saying I'm Kanya. In Kanya. Nyaya kuti zvoni zvinhu zvakononyora pakapisi kadhayari kuseri kwedhayari hazvishandi kana uchida sponsor license. Unonyora kapepa kanoisa muhomwe kanozowacherwa namadhamu hazvishandi. You have to have proper systems. You have to have proper HR systems, whether it's electronic or it's based online or whatever. HR systems, employee records are kept and so forth. If I was to ask a question to someone here that when you check the right to work for your employee, how do you store it? What do you check? What do you record on that right to check? I will not be surprised that 50% of the employers here don't even know. So they'll just say, oh, I copied the passport to the Home Office. That's not enough to just copy the passport and put it in the file. What do you record on that? So when we talk to our clients, we always advise on such matters. So the Home Office now do not just look at the immigration aspect of the business. When they come, they will leave no stone unturned. They will look at everything, and they can even want to whistleblow to other departments if you're breaching any other things as well. So make sure everything in your company is in order. So the other point that I've said is on recruitment, if you do not have hours to work, do not recruit. Don't just bring 20 people when you know that you don't have the hours, you're not on a framework, you don't have any work and so forth. It's a kusa kumsana nekudumbu because unoda vashandi kuti uwane contracts, but unoda contracts kuti uwane vashandi. But the Home Office has got a certain minimum number of hours that you have to give to the clients, to your employees. The Home Office expects you to pay a certain amount of money to your employees. So you have to balance these things. If you're going to bring a certain number of people, just make sure that you are able to supply them the jobs, and they're also allowed an additional 20 hours with the consent of the employer, that is, to work elsewhere. So you can bring them to work for you for your hours, and then you can outsource them, or they can go and work for another company, for your friend's company, or whatever, depending on the circumstances.
Can you clarify that one? Say the consent of the employer. Does it mean that the consent of me was the sponsor, or they're just allowed to do 20 hours somewhere else whether I want to?
Okay, I was going to wait for the question and answer session, but we can answer to that. It is, in my knowledge, Mr. Ponzawaba, it is with the consent of the employer for them to go and do the additional.
I'm not sure about the consent aspect of it, but I think that they are allowed to do an extra 20 hours anyway, only if it doesn't conflict, I think, with their employment duties, but I'm not sure about that. I would have to.
Yeah, so that's the reason why I say it in the consent, because there's that aspect of conflicting.
Yeah.
So some of the jobs that people do, domiciliary care, for example, your employee works, they might come out of the house from, say, 7 o'clock in the morning, come back at about 9 o'clock in the evening, but they are paid certain hours. But because they are out, not all of the hours that they are working is paid. So your employee cannot then say maybe the 3 hours in between they are going to rush to work for company, if it's going to conflict with your business. So that's why I'm saying with the consent of the employer, because if you're going to then for those 15 minutes between my calls, go to work for company B, and then it's going to disturb my business, then I think that is a conflict that will occur there. Okay, so as an employer, these are the duties that you have. If you go on slide number 7. As an employer, these are the duties that you have. Having a sponsor license, like I've said, it's not a right, it's a privilege. You have to comply with the law. I'm going to come to some of the common complaints by the employees and common complaints by the employers. But you have to comply by the law. Where you have to make sure that there's health and safety for your employees when they are going to go into people's houses as a lone worker. Then there's a lone worker policy. If they are going to go into a dangerous environment, you've got to supply them with all the equipment that they are supposed to have. It could be gloves or aprons, whatever job that they do. The employment law, the health and safety, all the rest of the laws that are there to be observed, you need to observe them. The employers have got duties to the UKVI from day to day, from the day that you are granted your sponsor license. So you have to make sure that you are keeping your records, you are reporting everything that needs to be reported. Things like the employee have failed to start the job, they've been absent from the work without permission, they've been dismissed or resigned, or the employer still stopped sponsoring the employee for any other reason. It's best to report to the Home Office than not to report to the Home Office. Because if then they say maybe, let's see your logging in details for clients that have been, not clients, for employees that have been reporting for work, your clocking, let's say your clocking in system, and then they see that your employees were not clocking in, but you didn't report, then that can be a cause for maybe you to lose your sponsor license. So where there's changes, there's a change of job title, salaries, location, changes, you got your employee to say they're going to work in Leicester, and then now you're putting them in Coventry. You might need to inform the Home Office of all the things, if there's tube that have taken place, and all those reasons, all those duties that I have mentioned on there. I cannot overemphasize that you need to keep your records. well, at the end of the day, the equipment are tired as well. But you need to be keeping your records. If you read Appendix D or on the guidance of keeping records, you'll see what the kind of records that you need to keep for each employee. So the Home Office, when they come to do your inspection, they don't think that they're going to just look at the records of your sponsored employees only. They will look at the records of your non-sponsored employees as well. They will look at your policies. Are you sticking to your own policies? And on the aspect of keeping records, I've often asked people who have done their own applications, and then I say, do you have a copy of the application that you submitted to the Home Office? 9 times out of not, some people don't have it. Oh, I submitted online. Did you download the copy? No, I did not download the copy. So what did you say to the Home Office? I don't remember what I said to the Home Office. You are in a precarious position if you're like that, because the Home Office, when they're going to inspect you or to visit you, they will see what you have said in your application letter. If you said you were doing domiciliary care and now you are now sending people for supported living, or you are now doing something else, then they'll say you have deviated from the reasons why we gave you this sponsor license. Can you justify yourself why this is happening? So there is need for you to just make sure that you keep all the records, your payroll is up to order, your taxes are up to order, and the rest of it. In church, when you are going to the next stage and looking and reading, they say, okay, or amen. Okay, so the 2 main aspects are, if you go on slide number 10, slide number 10, please. So with the sponsor license also comes with it the employment law, because the much queens are, you cannot separate the two. And it is very important that you have got a properly drafted employment contract. People have got a habit of just downloading any general contract, and they don't really, some employers don't really know what the terms and conditions they pay to their employees. And how did you sign that a contract which you don't even know yourself as an employer with your employee? When you get in trouble, you are now scratching your head because maybe the contract has given certain element of advantages to the employee which you thought in your head they didn't have. So make sure you've got a properly drafted contract, and the contracts are signed. I've had situations or I've had stories of contracts not being signed. Someone has been saying the contract, while they're still outside the country, then they come here, the contracts they've not been signed, and the contract that was given to the Home Office might then be the different contract than the one which they're signing here. There's a discrepancy and things like that. So there's need for consistency. There's need to have the contracts done well. The terms and conditions are there. Grievance and the disciplinary process are clear. Salaries is another issue that people who are the employees, as I mentioned, some employees who say we are not paid on time, which may be a point which was raised by Mr. Chipamura yesterday, that sometimes the employer has submitted their invoice to the council or to the NHS, whatever, but you've got maybe 12 weeks before you are paid. But the employee really wants their money month end or end of the week or whatever they need their money. So if you can't pay it on time, make sure you try to do whatever you need to do to make sure that the money is there. If you're going to go into factoring of invoices or a loan or whatever things that needs to be done. We have to meet the minimum wage and the salaries that are appropriate for the skilled worker visa, which I've mentioned in this particular circumstance. Right, so these ones will interest me more. My time is over, isn't it? I'll go through. So common complaints from employees. Abusive employers. but it can also be a misunderstanding on the part of employees. And it's also important maybe, and most employers are now doing this, that before your employees come from whatever country that they're coming from, you have a proper and honest conversation with them. People back home or from whatever country they're coming, they've got wrong expectations or too much expectations. My wife was speaking to someone who said that as a carer, they would expect to be paid 4,600 a month. And people have got wrong expectations, you know. And then I said, even on my own dividends, you know. And some of them, so if you talk to them, tell them the truth, you know, when you come here, you're going to be on 1,500, the rent is going to be 700, and this is the money, you're not entitled to benefits. You're not going to start as a local student for the next 5 years because you're on a limited visa. So don't think that if you run from here, then you're going to be a free person, so because whoever is going to employ you. So they say that we are abusive employers, and then we've got too much. They've got in brackets unlawful deductions, and that is an interesting point because it brings into a territory that is interesting. What can we deduct as employers? What can we legally say? The skilled worker fee can I deduct it from my employee? The visa fee can I deduct it from my employee? The flight, whatever. Most of these things are contractual. They have to be couched into a contract. There has to be somewhere so much that your employee will not be surprised when you are saying we are going to deduct 2,000 or 1,000 or whatever from your salary or yourself. Can you cover yourself for these costs because you are coming to the UK? So those issue of deductions, if you don't have a clear position, you need to have a clear position. If you want legal advice, me and Ruby are there. You know where our offices are. We talk and then we do a consultation. Some hours are not paid, poor accommodation, then some are verging on modern slavery. Sometimes people get less hours, or some people are made to work more hours than is necessary, and so forth. The next one is common complaints from employers. We have had situations of employees saying, once akaona kuti kwakasviba kuti handiende kubasa nokuti unokuti zuva rinenge richibuda na8 nechidoka na4 kwakasviba handiende kubasa. But it's time to go to work. And if it's maybe your relative, they become envious of you. Actually, is a nice driving a nice car. In 20 years, and they go over. You owe you shika. After so many years. Then the other one is, the employees are using us once they get here. They can try to switch, and the law doesn't stop them from doing that, does it? No, it doesn't. They can come here, and then employer B can offer them a job, and then they can go there. They just need to change their own single estate dependents. Don't need to apply for a new visa if it's in the same category, and so forth. So they can play you, or you can be played by the employees, and so forth. Then there's some unnecessary demands which may be made by employees, and so forth. Exaggerated CVs is another one. People exaggerate their CVs, and I had another case which the Home Office was dealing with about an exaggerated CV, and then said, have you done your own due diligence as an employer to really check what this person, because if this person is being dishonest on their documents, then we want them to trust them with someone's life. That's someone's life. What are things? Are they going to keep records really? Are they going to record, log into the file for the client when they go to see them, and so forth? Okay. And it's also important for us as employers to promote staff well-being. We don't have to be nasty, we have to promote their well-being. There are people that are still relocating. Some of them don't even know that Lido is cheaper than Asda or Sainsbury's. Such basic information, you just have to tell them where to go to top up their electricity if they live in a house
with topping up electricity and so forth, and provide training, etc. So compliance. Compliance is very important. You need to give the regular updates to the Home Office, which we have discussed and talked about. And you also have to be reviewing your own systems, whether they are up to scratch or they need to be updated, or you need to do something about them. You know, everything is dynamic in this country. You might have a case management system that you are using, or a client relationship management system that you use, or any other software in HR system that you use for your HR, or your clocking in system that you use. Make sure that everything is robust and everything is working well, so that when the Home Office comes, then you'll be able to deal with that. Observing GDPR. This one is an important one. You need to be observing GDPR as an employer. You know that and this happens, but when I sit on level one user and the freedom system, that's breach of GDPR. And they all registered level one user, if I put assistant or home office under the cabinet, according to the law, GDPR needs to be observed for whatever reason it is, for employees and for employers. And then I just hate to repeat myself again, and I have to just say it again 3 times. Keep records, keep records, keep records. So the Home Office might come for investigations. They might come, they might make an announcement to you to say that we are going to come and inspect you. You have to prepare A, B, C, D. But they might also make an ad hoc or an announced visit. And most of the time when they come unannounced, it's because there's a whistleblower that has contacted the Home Office, and then the whistleblower might be a past employee, a current employee, a service user, and so forth. So they might just come in because someone has reported to them. And they can do their investigations. So once they do their investigations, either they will see that you've done nothing wrong and you continue with your business. They might suspend you during the period of investigation. And if you are suspended, you are downgraded from A to B. And if you are under B, you cannot do anything much, because all you can do is just to submit your representations to the Home Office. If your license is revoked, then there's a cooling off period of 12 months before you can apply for a new license. And if you are going to apply for a new license, then the Home Office would want to see that you have addressed the reasons why the previous license was revoked. These are some of the penalties that you can face. You can get a suspension, you can get a revocation. If the Home Office concludes that you employed someone unlawfully, you can be fined up to 10,000 or 20,000 for each breach and so forth. You can have the downgrading of your rating, the application will be refused, rejected, and there's also possible criminal proceedings that might be there. This is my end slide. That's us there. And you might come to us, you might go to any other organization. I can vouch for Ms. Kudaba and ourselves that we can do a good job. She's in another organization, Tulia, that is at the back there, and this is our contact details. It is Tamlo Solicitors. This is something that cannot be done in 30 minutes, but I've tried to push through, because my initial consultation with clients normally on this topic would last nearly an hour to 2 hours discussing every day. Thank you.
Brilliant. Thank you. Thank you so much, Mr. Namara. Tamlo Solicitors.